Jeffrey Rosen, you are the expert on the Constitution. And what struck me as I was reading in on this over the last couple of days was it's essentially Section 3, a paragraph, right? We counted it. It's 110 words. The implications of the decision that, again, that the justices are going to make is so huge. Talk to me about the Constitution and why we're still debating individual words, individual phrases, and of course, always with the Supreme Court, an interpretation.
You put it so well. The Constitution is made for people of different points of view, as Justice Holmes said. And it really is remarkable that the whole nation is parsing words, the difference between office and office holder, between engaging in insurrection and inciting insurrection. And in a sense, it's sort of inspiring that we're all lawyers now, because every citizen has the ability to read the text of the Constitution, to learn about history and make up our own minds. It's true, it was very significant that the justices were converging around the idea that a single state should not be able to decide something like insurrection for the whole country. It was so significant when both Chief Justice Roberts and Justice Kagan expressed concern, well, what if a state, a Republican state, goes after the Democratic candidate and suggests that, for example, President Biden committed an insurrection with his immigration policies? Should they be able to decide the election for the whole country? And that sort of center of the court between the liberals and the conservatives converging around that danger was very significant. We also saw some really interesting agreement between Justice Gorsuch and Justice Jackson about whether or not the president is covered under Section 3 of the 13th Amendment. And Justice Jackson suggested the core meaning of the Civil War was to ensure that state insurrectionists couldn't continue to foment revolution. They just weren't thinking about the presidency. And it's since the whole argument really is an invitation to think about the meaning of our history and the Civil War. We're now polarized in America more than at any time since the Civil War. Like then, we're seeing violence in the streets as we did on January 6th. And the question is, to what degree does the Constitution protect democracy against those who would overthrow it? And although all of the Supreme Court justices were attentive to that question, they did seem to be converging around the idea that that's not the job of a single state. It's not even the job of the Supreme Court. Ultimately, Congress will have to decide that question.
Well, let me go back to that, because indeed, one of the biggest questions was whether upholding the Colorado decision would give an undue amount of power to a single state. Let me play part of the arguments today.
Why should a single state have the ability to make this determination, not only for their own citizens, but for the rest of the nation?
Because Article 2 gives them the power to appoint their own electors as they see fit. But if they're going to use a federal constitutional qualification as a ballot access determinant, then it's creating a federal constitutional question that then this court decides, and other courts, other states, if this court affirms the decision below, determining that President Trump is ineligible to be president, other states would still have to determine what effect that would have on their own state's law and state procedure.
Well, I mean, if we affirmed and we said he was ineligible to be president, yes, maybe some states would say, well, you know, we're going to keep him on the ballot anyway. But I mean, really, it's going to have, as Justice Kagan said, the effect of Colorado deciding. And it's true. I just want to push back a little bit on, well, it's a national thing because this court will decide it. You say that we have to review Colorado's factual record with clear error as the standard of review. So we would be stuck. The first mover state here, Colorado, we're stuck with that record. And, you know, I don't want to get into whether the record, I mean, maybe the record is great, but what if the record wasn't?
Okay, so you have heard and you have seen, Jeffrey, so many of these arguments over the years. You've read, I wouldn't even want to guess how many Supreme Court arguments you've read over the years. Can you hear in what those questions were, in what the entire argument was, where they're leaning?
I have to say, I thought back today to Bush v. Gore, and I remember very distinctly being in the courtroom back in 2000 when the court stopped the election by a 5-4 vote, and all of us were wrong in our predictions about what the court was going to do. I was sitting with great Supreme Court journalists, and we all thought that the court wasn't going to get involved and would not stop the recount, and it did. So that's given me great caution about predicting what the court will do, especially in these high-profile cases, which are literally unprecedented and are a mix of law and politics. That said, this oral argument seemed to show more consensus than many, and the fact that liberal and conservative justices were converging around the idea that a single state should not be able to remove someone from the ballot suggests that there could be grounds for unanimity, which Chief Justice Roberts always likes and tries to achieve if he can get it. And you could imagine a short decision by Chief Justice Roberts suggesting that a single state cannot enforce Section 3 on its own. But I really caution to say anything could happen. And with the Supreme Court, surprises are much more common than predictions, and it's possible that this case could be decided on different grounds.